Welcome. Thank you for your time and watching this video. My name is Ryan Gerdes with the Real Estate 401k Group, and I wanted to go over the new residential listing contract and exclusive right to sell. There's been some recent changes, and so wanted to make sure and highlight those, as well as go over the entire boilerplate of the contract so that you know what you're signing before you sign it. So this is what it looks like. This is page one. Owner slash seller. So that would be you, broker. That would be me, and West USA. And then part two discusses the property details, the address, and where the property is located, along with the assessor's numbers, which is identified under the county assessor's map. Listing price and terms. So if this is a rental agreement or an agreement for sale, then it'll be identified here on lines 14 through 16. The price, somewhat self-explanatory, but definitely you're going to want to make sure that you're doing all your proper research to make sure that you are pricing it accordingly to the highest marketability in the current market. Term, that's going to detail when this contract will begin and when it will end. Capacity, you must be someone that has the ability to sign this, nobody else. Modifications, any changes to this agreement must be done so in writing. Equal housing opportunity, all that you should care about is whether or not the money is green. Other than that, we are not discriminating based on anything here. We want to do business with anybody and everybody that we would like to do business with. Compensation. This is probably the biggest part that's been throwing a bunch of question marks in the air. I'm going to read this word for word here. It's all in bold. The listing broker compensation is not set by law, nor by any board, association of realtors, multiple listing service, or in any manner other than is fully negotiated between listing broker and owner in this agreement. Should the owner choose to offer compensation to a buyer broker or tenant broker, the offered amount is also fully negotiable and agreed upon after discussion with the listing broker. Take a couple of seconds to focus on that, because in layman's terms, what it is saying is you as a seller are not required to offer compensation to a buyer's broker whatsoever. Furthermore, we're not even able to market any type of offerings to a buyer's broker. The only time that is going to come up is when a buyer's broker and a buyer come and take a look at your property and they say, you know what, we would love to make an offer, but we also need to discuss compensation to the buyer's broker. And then at that point, it becomes a negotiation. So there's nothing set in stone. However, you as a seller are going to want to consider offering compensation to a buyer broker in order to remain more competitive. And that's just my personal opinion. But moving forward, all funds are to be in U.S. currency. Lines 39 through 42 discuss any type of possible retainers. Lines 43 through 46 itemizes and details what exactly is going to be paid to your listing broker. And then any other additional compensations in the instance that there's an unrepresented buyer on lines 48 through 49. Let's say somebody calls off the listing broker sign and says, I'd love to buy your home. They do not have any representation. Is there going to be any additional compensation paid to any broker? That's what's going to be there. I'm sorry, not any broker, but the listing broker specifically. Lines 50 through 60 illustrates exactly what you are going to want to permit your listing broker to offer as compensation to buyer brokers. Rentals. It's going to be a little bit repetitive and redundant here, because it is going to discuss pretty much the same type of compensation, but not in the event of a transaction, but in the event of a rental. Moving on to page 3, rental renewal or extensions. This is just an extension of the rental portion of this agreement. This is discussing, should a tenant renew what type of compensation will be paid in that event. And then, of course, if there's a purchase by a tenant, lines 81 through 83, whether or not there will be any compensation to the listing broker in the event the tenant down the road decides to buy the property from the owner. Lines 84 through 87, if there are any disputes in regards to compensation to any broker, that they will be settled after the close of escrow. It cannot compensations cannot interfere with the transaction. Withdrawn or canceled listings. Same amount of a sale or rental compensation will be due and payable to a listing broker if, without the consent of the listing broker, the premises is withdrawn from this agreement, otherwise withdrawn from the sale or rental, or is rented, transferred, or conveyed by owner through any other broker otherwise. It's basically saying that if there's you as an owner have all the rights to withdraw or cancel a listing or stop marketing your property, that is well within your rights. However, there still possibly could be compensation due to either a listing or buying broker. Payment from escrow or rent. This is essentially instructing that all the funds go through an escrow company in the event of a transaction more often than not. When it comes to rents, that's more often than not handled through the broker trust account. Lines 96 through 101, after expiration. This has to do when if you have your home listed, and let's say that this contract expires, and then there's a holdover, which would be identified on line 98. If there's a holdover period, then that would ultimately resurrect this contract. So if there's a 30-day holdover and a week before this contract expires, a buyer were to go into your property, show interest, but didn't write an offer until a week after this expired, and a contract was procured, then that would resurrect this contract and, more importantly, make compensation due to the brokers that are involved and agreed upon. Failure to complete. That simply says that if we, as your professional representation, do not perform and do not close, no compensation is due. Construction. To the maximum extent permitted by the applicable law, this agreement shall be construed as limiting applicable provisions of law relating to when compensation is earned or payable. In the event of any express disagreement between any provision of this agreement and the requirements of the applicable law, the applicable provisions of this agreement shall be deemed as modified to the minimum extent necessary to ensure compliance with applicable law. Now, that's a lot of redundancies in there, and ultimately, it's just saying that in the event that something, if there was any type of services or anything that goes along with your agreement with this listing contract, there may or may not be compensation due, but that would be something that it would have to be illustrated in writing and agreed to beforehand. Fixtures and personal property. There's been some changes in the recent future. One thing most notably is that has to do with wall-mounted televisions. So televisions that are wall-mounted, which is very, very common with big flat screens, the mounting apparatus will be required to stay on the property, but the TV themselves are considered personal property and go with the owner unless otherwise agreed upon in writing. Other than that, anything that is nailed down, affixed to the property, glued down, that is going to stay with the property. Anything sitting loosely about is going to be considered personal property. Big question that we commonly get faced with is, what about refrigerators, washers, and dryers? In the state of Arizona, we look at refrigerator, washer, and dryers as personal property. However, it is generally used as a negotiation tool between buyer and seller should the property have refrigerator, washers, and dryers on the premises. If you have any questions about this, please contact your real estate 401k professional, and we can help give you clear and concise direction on that. Leased or not owned items such as solar, alarm systems, propane tanks, or water softeners. That's definitely something that is going to be required to not only be disclosed to a potential buyer, but what that looks like in terms of negotiations. So that's something that you're going. If you do have any of these items, make sure you are familiar with the contract that you have with the company that is providing those items to ensure that you don't run into any trouble in the future. Agency, owner representation. We, as your listing broker, represent you and you alone. Okay. So if another buyer or another agent comes along and shows interest, we are going to continuously watch out for your best interests. However, we do have to disclose any adverse items that may be on the premises. So if you have a leaky roof, we must disclose that, whether you like it or not, if we know about it. Conduct of brokers, regardless of who we represent, that kind of goes along with the leaky roof. We must remain honest and do everything that we can to remain fair to all parties in the transaction. But still, if there's any type of personal information or any of those types of fiduciary duties, we owe those to you as an owner and you only. Limited representation. This actually happens quite frequently. This occurs when we are representing you as a seller, and then we have a buyer come along that we know that might be interested in your property. We have a lot of buyers in our coffers, and so it is very common that we will bring a buyer that's interested in your property. And so who gets the fiduciary is usually the common question. The answer is it's limited. So there is going to be less things that we can disclose and less things that we can do contractually and legally in order to move through this transaction. So um, it does happen fairly regularly, and it's something that you need to be aware of. And in the event that that does occur, we need to have a discussion. What listing broker cannot disclose to clients under limited representation? Confidential information. So if there's anything that has to do with your personal life. Number two, the price or terms of that you may take. So if you're offering your property for $1 million, but you tell me you're willing to take 900, I cannot disclose that to a potential buyer. All I'm going to let them know is that you would accept a purchase price of $1 million or whatever that listing amount is that we've marketed. The price or terms of buyer is willing to pay without permission of the buyer. That more or less has to do with if we're representing both buyer and seller. We cannot come to you as an owner. If a buyer says that they're willing to pay more, we are not allowed to disclose that as well. A recommended or suggested price or terms a buyer should offer, because until that time comes, we represent you and you only contractually. And a recommended or suggested price or terms the owner should counter or accept. So you as an owner, we cannot tell you, hey, look, you should accept this price or terms from that buyer. We simply end up in that type of situation giving you data and giving you information and then allowing you to make an educated decision based on that information. All right, competing owners. Owner understands that the listing broker may have or obtain listings on other properties, and that potential buyers may consider, make offers on, or purchase through a listing broker. Property the same or similar to owner's premises. Owner consents to the listing broker's representation of owners and buyers of other properties before, during, and upon expiration of this agreement. That simply says that if we do have a buyer that's interested in your property, that we still have the right to show them other properties that may be competing with yours, because we do have a responsibility to be fair and honest with buyers as well. All right, broker authority, listing broker's role. Listing broker is not responsible for the custody or condition of the premises or its management, except under separate contract, upkeep, or repair. Now, this is an interesting part because it is our responsibility if we were to, let's say, do an open house or show your property to potential buyers. We are responsible for making sure that property isn't damaged during those times. Now, within good respect of everything, there might be a little bit of footprints from traffic on the carpet, but not necessarily dirty shoes or anything like that. But moral of the story is, we need to make sure that we are respecting your property while we are marketing it. But it is not our job to maintain the property. Uh, our broker authority is to advertise your property to the greatest and highest of care. Multiple listing service lines 170 through 176 discusses that we are part of a local multiple listing service, and that is the primary location that most buyers and buyers brokers go to understand which listings are available and on the market. So that is definitely going to be the primary place that we do our marketing. But then what it's also going to discuss is any other platforms that may be out there. You might be interested, or you might use platforms such as Realtor.com or other platforms like that in order to get your information on what properties are available on the market. These share over. Lines 177 through 180 allows us or restricts us from putting a sign up. The only other thing that you should know about that is if you currently live in an HOA, they may or may not have restrictions on types of signage that is allowable. Lines 181 through 188, we do love photos. Buyers love looking at photos before they actually look at homes. We also love using video. So this is either going to allow or restrict us from using those photos and videos. What's important to know is to make sure that you don't have any personal items laying about that you don't want the public to see, because these do get published on the internet, and it will be available for all the public to see. Lines 189 through 194, lock boxes and key safes. This allows us to give other professionals in the industry access to your property. Now, we always make sure that it's scheduled. We always make sure that if you're occupying the property, that you know when a showing will be occurring. And more often than not, we are going to want to put a lockbox on the property in order to give them access. Lines 195 through 196. This requires us to, or this either allows us or restricts us to authorize to disclose the existence of offers, and which is different than accepted offers, but we'll get there. Lines 197 through 200, subsequent purchase or lease offers. That is illustrating that in the event you accept an offer, we are required to let anybody and everybody else know, up to and including potential buyers and buyers brokers, that we have accepted a contract on the property. That doesn't mean that you can't entertain other offers, but if you do decide to accept another offer, it will be in second or third position, whatever is relative to any previous offers that you have accepted. All right. So cancellations, listing broker reserves the right to cancel this agreement unilaterally for cause, which shall include but is not limited to listing broker's good faith belief that any service requested of listing broker or any action undertaken by anyone other than the listing broker is or could be determined to be in violation of any applicable law. This happens most commonly if there's a seller that demands that a listing broker lie to a potential buyer or not disclose known defects to a property. Those are probably the most common ones, but it is not limited to just that. Owner's obligation, or premise access. When you go under contract, you are required to allow access to a buyer to perform things such as inspections and walkthroughs, etc. Um, but there's it all has to be in good taste. Security, insurance, showing audio and videos. So we want to make sure that your property remains secure and safe and doesn't have any breaches, so to speak. But also, you may have recording devices. The rings and the blinks are extremely common these days. We love those, but if you are recording buyers as they're walking through your property, we must disclose that. Adverse information, line 219 through 226. Make sure all the information that you are putting that you know about the property on the seller property disclosure statement, or as we call them, the SPUDs, and make sure that the information that you're putting on there is accurate. Disclosures. This entire section is going to go through affidavit of disclosure. This is more common for rural type of properties. Disclosure of lead-based paint. This more or less has to do with properties that are built built before 1978, so 77 and before. Domestic water well addendums. If you do have a well on your property, there are disclosures that are in alignment with that. Foreign investment or in real property tax act certificate. We call that FERPTA for short. So if a buyer or if you as a homeowner are not a U.S. citizen, there could possibly be some ramifications or some requirements with that. If you live within an HOA, we do need to disclose that and all the terms and conditions the HOA requires the new owner to adhere to. Insurance claims history. If you have ever had any insurance claims, those will need to be disclosed. Or even if you haven't had any insurance claims, that will need to be disclosed. Residential lease agreements. So if you're leasing your property, you will need to disclose everything you know about the property. And or if you do have a property leased and you are wishing to sell it, you must disclose the information regarding the lease or leases in place over to the potential buyers. The seller property disclosure statement, as we previously discussed, is going to give you a laundry list of questions that will identify what is most commonly known to be adverse items on a property. Solar addendum. If you have solar on your property, you're going to need to disclose any and all information regarding that. Recommendations. All right. So we at the Real Estate 401k group, we work with a ton of different people, whether it's contractors or professionals in the financial industry, the lending industry, the insurance industry, the inspection industry, the tax service industry. I mean, anything and everything that you can think of, we've got a person for that. Ultimately, it is on you as a homeowner to hire that individual or hire that company to perform those services or provide those goods. We are simply going to give you the people that we've worked with in the past and who we've vetted and who we trust. But again, it is 100% on you as the homeowner to hire them. All right. Indemnification. So in regards to any recommendations, etc., we will not be held responsible should something go awry that isn't directly underneath our umbrella as your listing broker. Remedies, alternative dispute resolution. Now, ultimately, if you have a concern or a problem, voice it. Let's talk about it as responsible adults. But if there's any issues from there, then you definitely are going to want to bring it to the designated broker of our brokerage and work it out from there. Attorney costs and fees. This simply states that If there is a dispute and money is part of it, then the person that loses pays all the attorney fees. If there are any additional terms and conditions, they'll be outlined on lines 292 through 305. Assignment: neither listing broker nor owner may assign any rights or obligations pursuant to this agreement. This essentially says that there is no bait and switch allowed. Arizona law, this is a legally binding agreement. Notice: notice must be done so in writing. Days, line 315. Days are all done in calendar days. Contracts don't care about weekends or birthdays or holidays or anything like that. If we or you as a homeowner say that we're going to get something done in 30 days, you have exactly 30 days per the calendar. Copies and counterparts. This essentially says that hard copies and wet signatures and whatnot, they're all applicable. And furthermore, there can be additional addendums that are added later that are going to be applicable as well. This is an entire agreement, and acceptance is going to give information down here with the owner's information, the listing broker's information. And that, my friend, is it. Thank you so much for watching. We'd love to answer any questions. Hopefully this helped spell things out in layman's terms, and we are excited to work with you. Have a great day.